how to appeal for a speeding ticket in Ontario. For the purpose of this video, we're going to assume one thing, and that is that what you're asking is, what do you do if you've already been convicted under Section 128 of the Highway Traffic Act for speeding? There are two remedies that could be applied depending on the situation, which would help. One is called a reopening. Situations that involve reopening are situations where a defendant, I've had clients that have gone out of the country or there's been an emergency and the ticket has been misplaced and ignored too long, and by default, by the defendant not acting quick enough, they've been convicted. In a situation like that, relatively effectively and relatively cost-effective, we can file the paperwork, bring it back before the court, and end up with a new court date, which we can take from there and then assist the client. And the conviction has been alleviated in most cases, and then at the end of the day, either eliminated completely or mitigated. The other types of convictions are a bit different. And that is, if you've taken your ticket and you've paid the ticket, that's considered to be pleading guilty. And when you plead guilty, there is no mechanism available such as a reopening. The only mechanism available at that stage would be actually to appeal the matter. Now, there's two types of appeals. One is something like that, and the other would be, has the matter gone to court, if it's been in front of a judge or justice of the peace, and that court has decided that there should be a conviction? Well, in those cases too, the only mechanism available would be what I call a formal appeal. You would need to develop proper grounds to appeal. It's important to note that, and the reason why that's important is because there are many things that defendants consider legitimate grounds of appeal that simply are not. And it's unfair for defendants that are heading into a courtroom that way, thinking that their grounds for appeal have merit. Some of the weak grounds that clients have gone into on their own have been, well, you know, I paid the ticket, for example, and now my insurance rate has gone up by a multiple of 5. It's gone from $1,000 a year to $5,000 a year. An obvious tragedy, an obvious problem, but it is not considered a ground in the courtroom and therefore would fail at the appeal. That's one possible problem. So my point in telling you that is the ground is very specific. We would be looking for things like error in law, error in fact, or we didn't have an opportunity at the trial, for example, to present evidence that could have been exculpatory. If considered, they may have escaped conviction. In those situations, those are considered reasonable grounds, and if a appeal court judge considers that and he thinks, he can decide one of two things. He may dismiss the matter at that stage, or he may direct that a new trial be ordered. Those are important things to have happen, but in order to get those things to actually occur, the proper steps have to be made, and much consideration has to be taken into how we would get to that location. If granted, what would happen in most cases, you would be ordered back to trial. So the conviction would be lifted, and on another day you would start the process all over. There are and have been situations that I've dealt with, and most of my staff, where the conviction, sometimes through no fault of their own, causes great problem in their life, perhaps even the loss of their employment. In those situations, there's special considerations that have to be taken on that appeal, special paperwork that needs to be filed with the appeal to get what I call relief. And one of those particular documents would be a stay. A stay would lift the conviction immediately until it can get before a judge, for a judge to properly consider what those grounds are.